Good afternoon, everyone. Welcome. We want to thank you for joining us on the line and live in the room for Venable's program on the new Secure Act. I'm joined by my colleagues and my friends here on the podium today. We have Harry Atlas, Juliana Reno, and Lisa Tavares. We're all members of Venable's Employee Benefits and Executive Comp Group. Again, excited to talk about the Secure Act. Time is a bit tight, so with that in mind, we'll hold questions to the end. And for those in the room, there'll be mics. And for those who are on the webinar, there's a way to submit questions online. And so diving right in, the Secure Act is part of the 2020 Appropriations Act. Its name suggests exactly what it's trying to do, setting every community up for retirement enhancement. And it does it through a number of ways. The enhancement is focused on encouraging annuitization of retirement benefits, providing easier access to retirement plans for those in the gig economy, those working part-time, and for small businesses. It also reflects the fact that Americans are living longer, and this is seen in the changes to the required minimum distributions. It has revenue raisers as well, allowing in-service distributions at age 59 and a half for governmental 457 plans, and it eliminates stretched distributions for retirement. And outside of the Secure Act, but still within the Appropriations Act, there are a few health and welfare changes that we'll discuss at the end. And with that, turning it over to Harry Atlas.
Hello, everybody. Thank you for joining us today. Well, let's start by discussing changes made by the Secure Act to the required minimum distribution rules. These are the rules that require qualified retirement plans and IRAs to begin distributions at specified ages and at death, and to be made over various life expectancies. These rules are very significant from a participant's perspective because they impact their lifetime tax and income planning, and they're also significant from an estate planning perspective, which we'll not focus on today, as well as from a government revenue perspective. The Secure Act makes important changes to the lifetime required minimum distribution rules, as well as the post-death minimum distribution rules. Today, I'm primarily focusing from a perspective of employer retirement plans as opposed to IRAs, although the rules are very similar, they're not identical. IRAs, the required beginning date is not key, does not depend on whether somebody has terminated employment. So the basic change, sort of the basic statement of the lifetime minimum distribution change, is that instead of minimum distributions being keyed to age 70 and a half, they're now keyed to age 72. And that applies to participants who had not reached 70 and a half by December 31st, 2019. So anybody who was 70 and a half by the end of last year, nothing's changed. However, if somebody is under that age as of the end of last year, the required beginning date is now age 72. This involves a number of potential changes from a retirement plan operation and administration perspective. For example, a lot of retirement plans say that, particularly in the defined contribution arena, but also in the defined benefit arena, say that a participant who's terminated employment can postpone their distributions until their required beginning date. That change is an operational change based, we don't have IRS guidance specifically yet, I'm sure we'll get it, but by the looks of it, a plan sponsor now has a choice. If a plan keys the beginning date to 70 and a half age, you're not necessarily required to change that to 72. In other words, you potentially could require participants to begin based on 70 and a half. Another important point, and this is really for defined benefit plan sponsors, right now there's a requirement that if you have a so-called suspension of benefit provisions in a defined benefit pension plan, which means that for participants who continue to work past the plan's normal retirement age, a lot of defined benefit plans will so-called suspend benefits, which means provide a notice to participants and not provide actuarial increases in benefits to reflect the later age. The Secure Act does not change 70 and a half in that context. So the statute still says that when somebody who is in service reaches 70 and a half, they have to receive an actuarial increase. However, there are some drafting quirks around that, and it's no longer clear how exactly that applies to somebody who has not reached 70 and a half by the end of last year. It's possible that they don't get that increase until they reach 72. Sorry about that. It was an arcane point, but an important one if you happen to work with defined benefit plans. Most of you probably have defined contribution plans, and there's another important nuance that impacts defined contribution plans operationally, and that is that if a participant takes a lump sum distribution from their plan and they've already reached their required beginning age, so typically this happens when somebody's terminated employment, they've reached age 70 and a half, and they want a lump sum distribution. So the tax rules say they've always said that a piece of that distribution, because it's a required minimum, is not eligible for IRA rollover, and therefore is also not subject to mandatory federal income tax withholding if it's not rolled over. So that lump sum distribution to somebody who's at the required beginning date is a piece of it is impacted by whether it's a required distribution. That gets a little bit tricky now that
Wait, I have a question.
You do.
Is it? Yeah, I do.
You do.
They're all surprised because I'm not a retirement plan lawyer. Is that the required beginning date in the statute or the one in the plan, or don't we know yet?
Well, what I'm describing is the required beginning date in the statute.
Okay.
Yeah. And the rule is really meant to kind of marry the different sides of the distribution to make sure it's all internally consistent. If you are eligible for rollover, then we do not impose then we do impose a mandatory withholding if you don't choose to roll it over. If it's not eligible for rollover, then you don't. Now, this does get tricky, though, with the Secure Act, because you now have two classes of participants with respect to this rule. You have participants for whom the required beginning date is keyed to age 70 and a half and to age 72. So,
Harry, do they make any changes to more than 5% owners?
No. So there's a special rule for 5% owners of a business that the basic rule for an employer plan is that the required beginning date is April 1st following the later of the year in which the participant reaches 70 and a half or terminates employment. For a 5% owner, the required beginning date occurs at 70 and a half, even if the person is still employed. That hasn't changed. That overall structure of the required beginning date hasn't changed. Congress just scratched out 70 and a half and added 72, but everything else stays the same. Moving. Yeah. Oh, going the wrong way. There we go. Okay. The next part of the Secure Act changes, and very significant from a personal planning perspective, relate to minimum distributions for after death, and these are widely referred to in the press as stretch distributions, stretch IRA, stretch retirement plan. You probably heard that term. Under pre-Secure Act law, if a participant had a designated beneficiary upon death, then following the participant's death, the account could be paid out over the life expectancy of the designated beneficiary, no matter how much of an age disparity there was. So if you designated a grandchild or somebody 2 generations younger, potentially that account could be paid out on a tax-deferred basis over multiple decades. The Secure Act retains that idea, but only for certain types of beneficiaries. And the changes, this is also really important, the changes as far as the effective dates, participants who die after 12/31/2019 are subject to the new rules. So anybody who's still alive, they're subject to the new rules. There's some different delayed effective dates for collectively bargained plans, and there's a grandfather rule for contracts that have already been annuitized. But the basic rule is that if the participant was alive on through December 31st, 2019, the new rules apply. And what the Secure Act does is it creates a new concept of a regular designated beneficiary versus a so-called eligible designated beneficiary. And the eligible designated beneficiaries are instances where Congress has viewed a long payout, I think, as being non-abusive. I think that's the way to think about it. So Congress has identified a class of beneficiaries for whom there's what could be viewed as a legitimate non-tax reason or legitimate reason to pay it out over a very long period of time. And that's the participant's spouse, a beneficiary who's disabled or chronically ill as defined by the code, or a minor child, or somebody within 10 years of the participant's age. In those instances, the beneficiary's life expectancy can be used. For other individuals, the maximum payout time is 10 years following death. So that is also a change. It used to be that the alternatives were to do a payout over a lifetime or a payout at the end of a 5-year period following death. And now for beneficiaries who don't qualify for the stretch rule, you have up to 10 years following death to pay out an account. For a lot of people, that'd be sufficient, unless we're in the estate planning context with really wealthy individuals. 10 years post death may be sufficient, and that's still available. Change gears here to a different topic. This relates to pooled retirement plans, or retirement plans that cover employers that are not related. As Tora mentioned, one of the purposes of the Secure Act is to expand retirement coverage, and in particular to expand coverage for the gig economy and for small businesses. And one way that the Secure Act looks to do that is to enhance the ability to provide pooled retirement plans. These plans they currently exist in different forms. It's not something that's brand new. For many years, there's been a concept of a so-called multiple employer retirement plan, which is recognized by ERISA and the code under pre-Secure Act law. And the basic concept of a multiple employer plan is that you have employers that are not related as a so-called controlled group banding together and forming a retirement plan. However, there are issues with pre-Secure Act law that needed to be addressed. For example, under pre-Secure Act law, the entire plan could be put in jeopardy as far as its tax qualification if one employer in the plan didn't do what it was supposed to, so-called one bad apple rule. Also under pre-Secure Act law, in order to have what ERISA views as a single plan maintained by a single group or group of employers, the employers have to have had some relationship to each other, like an association, where there's an existing relationship that is not dependent on the retirement plan. So a typical scenario would be an association, a trade association, could have sponsored a retirement plan for its members. But those are limited. So what the Secure Act did was that we now have essentially three types of retirement plans. Post-Secure Act, we essentially have the old, what I'll call the old type of multiple employer plans, which can be a 401k plan or a 403b plan, which is typically would be sponsored by an association. We have two new types of plans. The first one is called a pooled provider plan, and this applies for plan years beginning after December 31st, 2020. And the concept with a pooled employer plan is that a financial institution or a record keeper can essentially set up a plan. They're referred to as open multiple employer plans or open MEPs. So again, not something that's never existed before, but the Secure Act is officially allowing it, and under guidance that will be issued, or it needs to be issued by the agencies, will explain how a vendor or record keeper or financial institution can set up a single, say, a 401k plan that it could offer to all of its customers, and you would have a single 5,500. You'd have the financial institution is the named fiduciary. All the things that an organization does with its benefits committee, that would all be essentially outsourced. But you can outsource some of that today, but you still have liability. This would actually transfer the liability to the outsourced provider.
Hey, Harry. I'm sorry.
Go ahead.
Is there any play in here for 403b plans in this pool provider?
No, there's not. For some reason, which I don't know the answer to, Congress, the statute just refers to 401a plans, which are basically 401k plans.
So this would let Fidelity or whoever set up a plan for, say, any Uber driver.
Or any.
Or anything, but I'm just as a concept.
Yes, correct. For any Uber driver, right. That's right. And so that's the big change. The last thing on the slide, which is also really a very interesting concept that also needs to be fleshed out through guidance, is for plan years beginning after 2021, there's a notion that a financial institution can not have a single plan. It's not a single plan legally. Legally, there's a lot of different employers with their own plans, but it can file a consolidated 5,500 as long as the financial institution is the named fiduciary and you have the same investment menu. So it's very similar to the pooled provider model, but it's not exactly the same. And we'll see. As guidance is issued, we'll see exactly how it's different. But potentially, you could have each employer could have potentially more latitude and less joint liability. So the Secure Act, for traditional multiple employer plans, the Secure Act gets rid of the idea that if one employer is non-compliant, that the whole plan can be disqualified. It does the same thing for pooled provider plans and also provides some protection for non-compliance by the pooled provider. And under the third approach, the consolidated approach, plans do not bear responsibility for each other. Moving on to a different topic. This topic is I would say it's of great interest to a limited number of plan sponsors. If you have this situation, this is of great interest, and if you don't have the situation, this is no interest at all. But this relates to so-called closed defined benefit plans, and I'll cover this pretty quickly. But the upshot here is that over the years, as we all know, a lot of employers have frozen their defined benefit plans, and a lot of times when they've done that, they've said, "Well, we'll grandfather a group. If you're employed on a certain date, you can continue and you continue to accrue benefits. If you're hired after that date, you're in the 401k plan, or you get a less generous benefit." And that kind of works for a while. When you do it, it works that year, and then it works for a while. But over time, as your workforce turns over, your new employees tend to be less highly paid. Your longer tenured people tend to be more highly paid, and you end up with a discriminatory plan. The IRS has issued guidance, sort of temporary notices on this topic, but the Secure Act actually tackles this from a statutory perspective, and comes out with the following the following structure. The Secure Act says that if your plan satisfied the non-discrimination requirements for the year that it was closed and the following 2 years, if you meet that requirement using some relaxed non-discrimination testing techniques that were not otherwise available, and you don't amend that plan to significantly discriminate in favor of highly compensated employees, which is a relaxed standard. Usually you're not allowed to discriminate at all. And if your plan was closed by April 5th, 2017, or it was in effect for at least 5 years before it was frozen without any substantial change, a substantial increase in benefits, then you get a pass. And what they've done is they've preserved the basic idea of non-discrimination, but they've liberalized different aspects. And again, if you don't have this situation, this is not of any interest, but if you do have it, it's of great interest. With that, I will turn it over to Lisa.
Thank you, Harry. Go down. Okay. The Secure Act has created a different track for 401k participation for long-term and part-time employees. It's a tongue twister. One of the intents of the new provision in the Secure Act is to broaden employee participation, as Tora mentioned, to provide relief for the gig economy, some who are long-term part-time employees, and then to provide 401k gender parity, where there's an assumption that there are more women who are working part-time and being affected by the inability to get into a plan based upon the standard rules than men. So under prior law, long-term part-time employees could work for many years but not be included in a plan because there's a 1,000-hour requirement. You have to have 1,000 hours typically in a 12-month eligibility computation period. But now, under the Secure Act, a long-term part-time employee can participate and make deferral contributions only. So the new rule, as it's created, allows employees that worked at least 500 hours for 3 consecutive years to make elective deferrals as long as they had attained the age 21. And the elective deferrals have to be permitted to be made no later than the first day of the first plan year once they satisfied both that service requirement of the 500 hours and then the age 21, or 6 months after meeting that requirement. Employers are not required under this new provision, though, to make matching or non-elective contributions for these long-term part-time employees. So this was a significant hurdle that many on the policy side for years were trying to find a solution for. And so it does work for a portion of the population and should allow some people to have more retirement savings ultimately. But if the plan sponsor does provide an employer contribution to those long-term part-time employees, those ones that have gotten the 500 hours, they must receive vesting on those employer contributions. One of the benefits of the new provision, however, is that long-term part-time employees can be excluded from the non-discrimination testing. So, we've had clients that have had to change their plans to safe harbor plans and make other changes because some portion of their workforce is part-time. It may be seasonal, it may be call center, or something that has really been a problem on this 1,000-hour requirement and satisfying the rules and then providing benefits from employees. And then you start running into non-discrimination testing if you have people just getting over that 1,000 hours. So this rule is intended to sort of provide some relief where we're now going to have plans that are going to be including these part-time employees who otherwise would throw out the non-discrimination testing requirements.
Hey, Lisa, you're giving us a lot of detail here, but from another health and welfare lawyer, are these exactly like the 403B rules?
No. So the 403B rules, so there's this Yeah, no, it would be too easy. There's a concept in 403B called universal availability for tax-exempt plans, and it sounds similar, right? In those plans, you have to include these people that are part-time workers. But here, this is a whole new provision where we didn't have a concept of universal availability in the 401k context. So now this is some relief to allow people in, those workforce employees that never had enough hours, and allow them to get a benefit. So with the public policy that you outlined at the top. So the challenge for plan sponsors and record keepers is going to be getting this all lined up. It's going to be a change to both HRS systems and then the record keeping systems. Especially if, again, I said it was a different track. So they're going to be employers who are going to have this 500-hour track for these long-term part-time employees, and then a different track for your regular employees. And presumably your systems are not set up right now to handle that, and most of the record-keeping systems from even the big box record keepers are going to have to be revised to handle those requirements, as well as vesting tracking changes. So it will take some work. The good news is, although the rule became effective for plan years after 2020 rather, you don't have to start counting until 2021. So the service before 2021 doesn't count. So what will happen is in 2021, 2022, and 2023, employers will have to pay close attention to that 500 hours. It will give us some time to get things lined up, but it'll be here before you know it. And this and pretty much all the other changes, I'll add, at least on the retirement side, well, all of them, I guess, there is no guidance. There's this statute that is not even like the complete law, it's just the statute. So it's pieces of the law. So you have to sort of piece all of this together. So a lot of the details will also come out over the next 6 months to a year, presumably as different effective dates are triggered. And we'll go through today and talk about different effective dates and the rules. So now I'm going to change to a topic about safe harbor plans, and there's been a change to the timing of safe harbor election for plan sponsors. Before 2020, before the Secure Act, 401k safe harbor plans had to be adopted before the first day of the plan year, and they had to remain in effect for the entire 12-month plan year. We get questions all the time, is that for real? Like, people have to plan in advance in order to adopt one of those plans. And for companies that are trying to create a solution for non-discrimination testing they're trying to get out of, and they don't determine to the end of the year, that's a problem. Sometimes they're not able to put in the safe harbor plans, and then for other business reasons, people may later find out that they want to put in a plan. So this is relief. Because under the prior law, you had to also, in addition to the amendment, provide a notice. Under the new law, a plan may be amended to provide the non-elective contribution safe harbor plan at any time before the 30th day before the close of the year. There's also this other sort of extended time frame that's a little complicated, but it's essentially 30 days before the end of the close of the year. And then there's also another provision for the ability to, after the 30th day, before the end of the plan year, to elect the 4% non-elective safe harbor. And you can do that until the end of the following year.
And does that mean also anything more than 4%?
Well, presumably you could do more,
right.
But yes. But
I mean, I get it's a lower threshold, so.
But the minimum safe harbors are going to be the 3 or the 4%, and all the standard documents are going to be set up that way. So presumably you could do more. I never see people do more, but.
And what happens to the notice, the safe harbor notice?
So the safe harbor notice for the non-elective plan, safe harbor plan, is eliminated. There's still a notice for the matching. So that should eliminate some anxiety for at least one portion of the safe harbor universe and make things simpler. The thing that wasn't changed in the law, though, is that there's still this concept of effective availability to our opportunity to make a change. So in order to have this non-elective and not have the notice, you have to allow participants to make a change in their elective deferral amount at least once a year. So that's sort of based on an old IRS concept. The effective date for this particular change was at the end of 2019, so it's effective now. And presumably we'll start to see some guidance on this relatively soon because it has one of the earlier effective dates. Next, moving on to a different type of safe harbor arrangement is the Qualified Automatic Contribution Arrangement, a QACA. The Secure Act has also removed the notice requirement for the non-elective QACA. And the QACA, I know it sounds funny, right?
How can you say that and be serious?
I didn't name it. The QACA provides a special safe harbor from non-discrimination testing because there's a uniform minimum default automatic contribution, which starts at 3% for your standard QACA. However, the change that we're really focused on here is that the QACA limit of 10% has been increased from the old law amount of 10% to 15% in the new law. The trick to remember, though, is that the 10% still is required for the first deferral year, and then the second year you can go over the 10%. So if you think about it this way, it's sort of a stepped up level. So the 3 is the minimum. You can go from 3 to 10% in that first year. The second year, which is the first year after it's the second year is the first year after the first deferral period, is 4% to 15%, and then so on. So the second year after that first deferral period, which is the third year, you can do between 5 and 15%, and then in that fourth year, you could do between 6 and 15. So that first year has a 10% limit, and then it steps up to the 15%. Just to make it complicated and create compliance errors that then we can fix in the correction system for the IRS. So next, we'll talk about the enhanced ability for 401k and 403b plans to offer annuities and some related plan disclosures. This next set of changes that we'll talk about are intended to promote lifetime annuities. And the thought is that people don't really know how to manage their own money, so they need help in creating an income stream. The Secure Act makes 2 changes. One, that a plan participant can receive a trustee-to-trustee transfer of an in-service distribution, as in a rollover. They can take an actual distribution from a plan, and also a new fiduciary safe harbor rule, which we'll talk about in a little more detail. The important point here is that for our governmental plan sponsors, this particular rule applies for 457B governmental plans. We just don't generally put 457B on slides because people can't figure out if that's tax exempt or governmental. And so to clarify, for the 457B governmental plans, this benefit also applies to this change. So let's talk a little bit more about the in-service distributions of annuity contracts. If an annuity contract is no longer permitted and a plan is an investment option, the annuity can be distributed to the participant, or it can be rolled over. And again, that rollover would be in a trustee-to-trustee transfer. But the benefit of this from a policy perspective is that the employee doesn't lose the guarantee, one, that they've already paid for annuities that were in plans. And it allows plan sponsors to have the flexibility if they don't want to continue to have those type of options in their plans. And it doesn't mean that employees have to face the threat of having to terminate employment in order to receive a distribution when a annuity option is eliminated from a plan. That change is effective now. And so we would expect to see, again, some guidance that would come out. There's a notice requirement for the Department of Labor to issue for defined contribution plans on an annual basis that will show what the lifetime income stream really means. It'll show the equivalent. That notice is supposed to be issued by the Department of Labor in 2021. So presumably you'll hear more from us about that in the years to come. Shifting to the last set of sort of these annuity issues is the fiduciary safe harbor for selecting annuities. Under prior law, the plan sponsor is considered a plan fiduciary when the plan sponsor selects an annuity provider, which means that the fiduciary must act solely in the interest of participants and beneficiaries. That plan sponsor must consider the financial health of the insurer and the insurance company. So that's the good old fiduciary prudence rule that I'm sure most of you are familiar with. Again, Congress wanted to increase the number of plans that are providing annuities. And if you've talked to any of us, you know that we'll give you a number of cautions about generally before this act of adding annuities to defined contribution plans. So this is relief for that. The government had to come in and provide this new fiduciary safe harbor that could be relatively easily satisfied by plan sponsors in order to encourage plan sponsors to continue to have these annuity options, which again, from a policy perspective, in terms of creating a stream of income, is seen as positive. And the fiduciary safe harbor can be satisfied if the plan sponsor receives from the insurance company a representation that it complies with state law, and there's some other information they would provide. So the plan sponsors who actually want to provide this annuity as an investment option will have then been deemed to satisfy that fiduciary prudence requirement as to the selection of the insurer, and they're not liable for losses resulting from the insurer's failure. So that's sort of like the rules regarding 401k plans. Do you have a question?
Yeah, do you think that employers will be putting these in?
Well, I think primarily for employers that have them, particularly for plans that converted, from old money purchase plans that still have annuities, that gives them some relief. Some employers may really be paternal enough to want to add annuities, but I think it's a small segment of people that really needed a change and a solution. I think a lot of our 401k clients want to keep their plans fairly nimble. And this is just sort of one more hurdle. But the important thing with respect to the fiduciary safe harbor, I think, is that it is a reminder, even with the safe harbor, that you need to have expert advice in putting in these arrangements and in thinking about eliminating arrangements. I'm going to turn it back over to Harry.
Thank you, Lisa. We'll talk about a couple more changes made by the Secure Act. Under Pre-Secure Act law, a defined benefit plan cannot allow an in-service distribution as a distribution of somebody still working before age 62, except in an unusual case where the plan's so-called normal retirement age was earlier, but that's not usually how it works. So under Pre-Secure Act law, a defined benefit plan generally cannot allow a distribution to a working participant before age 62. And also under Pre-Secure Act law, a governmental 457B plan was not allowed to make an in-service distribution before age 70 and a half, with a couple of exceptions, but there is no concept of an earlier distribution. Secure Act changes both of those, and this is actually part of the bipartisan American Minors Act. It's part of the appropriations legislation. It's actually not technically the Secure Act, but it changes the rules. And if you have a DB plan, you can now add an in-service feature at 59 and a half. That actually may be attractive to plan sponsors that still have defined benefit plans, because it provides a mechanism for de-risking. We've worked with a lot of defined benefit sponsors on de-risking their 401k plans and allowing people to access their money sooner, particularly if you were to couple that with a lump sum option, might help de-risk a plan. For governmental 457B plans, also, it seems like the economic considerations are not the same at all, but there's probably no reason why you wouldn't want to add this if you're sponsoring such a plan. Another interesting provision in the Secure Act relates to a new penalty-free withdrawal option for birth or adoption. So currently, as we know, 401k, 403b, governmental 457b plans have statutory limits on their ability to allow participants who are still working to take out money from the plan. And at least for the 401k and the 403b plans, if a participant were to take a distribution before age 59 and a half, with some exceptions, there's a 10% penalty. The Secure Act makes changes so that 401k plan, the 403b plan, the governmental 457b plan may be amended to allow an in-service withdrawal for a participant who has had a birth or an adoption in their immediate family. And also for the 401k and 403b plan waives the 10% penalty.
Hey, Harry, is placement for adoption enough, or does it actually have to be a finalized adoption?
It has to be a finalized adoption. And so there's also provisions in the law relating to allowing participants who've taken such a distribution to repay it either to the plan that it came from or another plan, which there's a lot of questions as to how that's going to play out, but that's potentially complex. Yet another topic, this one's a revenue raiser. The law has changed dramatically in regard to potential penalties for failure to file Forms 5500, Forms 8955 SSA, and failures to provide notice of withholding elections. And the series of statutory penalties have been increased tenfold. So, I think the one which is probably most familiar to people is the Form 5500. If you're late with a 5500, it's a frequent occurrence that 5500 is not able to be filed in complete form on time. Maybe an audit's not done. Maybe there's an issue with it. Those penalties have now gone up. Instead of being a maximum potential penalty of $15,000, it's gone to $150,000. And similar increases to the 8955 SSA, which informs the Social Security Administration of terminated vested participants, as well as failure to provide participants who are receiving periodic payments with notice of their ability to elect withholding. Finally, one last point on the Secure Act, as far as plan amendments. A very a dry topic, but very important. So, when do you amend your plans? How do you do this? How do you do all this? So, this is, as you're probably familiar for 401k plans, 403b plans, there's a concept of being able to retroactively amend plans. And the Secure Act has a statutory retroactive date, and plans can be amended as late as the end of the 2022 plan year to reflect Secure Act changes, as long as it's retroactively amended. And there's even a later effective date for collectively bargained in governmental plans. So that gives the IRS time to publish the guidance, which we definitely need before we can actually draft detailed amendments. And with that, turn it over to Juliana.
Okay, it's health and welfare time. So there have been changes to a number of the fees that are owed by health and welfare plans. The first one is the most unpleasant, which is that the PCORI fee has been extended for another 10 years, which is super annoying because we all thought we were finished with it. It's a small fee for times the average number of covered lives. There's a bunch of ways in the regulations about how that gets calculated. If you have a calendar year plan, you calculate the average number of covered lives for 1 year, say 2019, and then you have to pay it by July 31st of the following year, 2020. So this just got extended. Other than that, it stays the same. The amount of the fee is indexed. This was originally adopted as one of the many pay-fors in the Affordable Care Act. Some of the other ones that we'll see on the next page. Oh, wait, before I go to the next page. If you are a large employer and you have a self-funded plan, you are paying this. If you're a small employer and you have a fully insured plan, the insurance company is paying this. And then there are employers who have a little bit of both, which is they have an insured plan and they have an integrated HRA, health reimbursement arrangement, that goes with the fully insured plan. In that case, the insurance company is paying on the fully insured plan and you are paying on the HRA. So that's how that one works. Okay, Cadillac tax. This is a pay-for the ACA that went away. And the concept was that people who are not getting employer-sponsored coverage don't get the same tax benefits as with respect to their health insurance as people who are getting employer-sponsored coverage. The employers are paying for health insurance, and they don't have to treat that as taxable compensation. So this was, one of the thoughts was, this would level things out a bit. Well, nobody liked it. They didn't like it because, for two reasons. A substantive one, which is that nobody wants to give up tax-favored benefits if they don't have to. And then there was also a procedural problem, which is that the indexing was a little weird. So the idea was it was only supposed to capture the very rich health plans. But because of the way it was indexed, the projections were that by about now, it was going to be capturing 40% of all health plans were going to be subject to this tax. So there was a couple different problems. It never went into effect. It got kicked and kicked and kicked the effective date, and eventually it got completely repealed. The other two taxes that got ACA pay-fors that got repealed are things that you probably don't have to worry about, but they're the medical device tax and the health insurance tax.
Before you move on, can we talk a little bit about the mandates, employer and individual?
Sure. So what she's getting at here is that there are some taxes that are still there. So the individual mandate is gone. So if you fail to have...
On the federal level.
On the federal level, right? We're getting there. So if the feds repealed, famously, the individual mandate, that means if you do not have health coverage in a given year, then you are not going to pay a penalty on your federal taxes. When they did that, states moved in to fill the breach. So there's a number of states that have adopted the individual mandates. So you now have to pay it on a state level, which is really screwing up everybody's reporting, which is another whole topic that we're not going to get into. So that's the individual mandate. The employer penalty is still in place. There's, again, changes to the reporting because we no longer have to give people stuff that they can attach to their tax returns, but the employer mandate has not gone away. In the states that have the individual mandate, again, there's all these tricky rules, which I'm happy to talk about if you really need to fall asleep in the next 10 minutes, about how the states basically are following the old federal rules. It's a little crazy, but
and just so people have an idea of states that they should be thinking about, think about Massachusetts, which is old,
right.
But New Jersey, D.C., California, Rhode Island, and Vermont.
Yeah, most of those are not, the reporting is not due this year. Massachusetts has been around for a while, so that's old news. New Jersey is this year. You need to report if you have employees in New Jersey. Okay, so those are the taxes still in place. All right, here's a nice one. Next one. Transportation benefit tax. So here's how this sort of works. In the old days, an employee could deduct money from their paycheck on a pre-tax basis and put it towards a transit pass. Other things too, but let's just go with this one. You could put it towards a transit pass, and that got the employer got a tax deduction for that because, you know, they would get a tax deduction if it was wages. So they got a tax deduction if it went somewhere else. Great. It's part of compensation. Then in the Tax Act, the rule got changed. Why did it get changed? Because the employers were getting a tax break, right? Their corporate tax rates went down. So they took away some deductions. This is the deduction that they took away. This is one of them. Okay, so now if an employee does that, the employer, no longer get to take that as a deduction. All right, what happened to nonprofits? Because nonprofits never took the deduction anyway. So the tax law said, well, the nonprofit employers have to pay unrelated business income tax on that to sort of level things out. You know who is really happy about that? For-profit hospitals. You know who's really unhappy about that? Every nonprofit ever. And amazingly, the nonprofits won this one. So what they got in the new law is they got relief from the UBIT payment, and it's retroactive. So if they paid it for 2018, which most of them did, they can go get refunded that money. We still don't have the exact procedures for that. We're expecting that kind of guidance. So that's kind of interesting that they won that one. A lot of people say to me, well, can't we just solve this by not giving our employees this benefit, right? Then we just don't have the problem. The answer is yes, unless you live in one of the places that requires you to give this benefit to your employees. I've got them on the slide. DC is one of those places. And in addition to the ones on the slides, LA is coming soon. So that was the worst part, right? The worst part was you're required to give this benefit and it can't be deducted. So there's also some complicated guidance that the IRS has provided on how to calculate parking. Because what do you do if you're in New Jersey and you're in, pharma land and they all have these gigantic parking lots, and how, they make them available, and what are we supposed to calculate? How are we supposed to do that? So there's some guidance on that one. And I think that is it.
Right, that brings us to questions. So we covered a lot of topics in a relatively short period of time. And for folks who can remember what we started with, if you want to ask questions, happy to take them in the room right now.
Can you step over to the mic, though?
For those on the webinar.
Hi, thanks for doing this. Early on, Harry mentioned that you weren't required to change your RMD age from 71 and a half to 70 and a half to 72. Are there any advantages in not changing it?
That's a good question, and I also would caveat it that we don't have any guidance yet on it, so the IRS might yet say that you are, but I think based on what we know, you're not required to. I think the advantage would be simplicity. I think if you do change it from a plan operational perspective, you now have two classes of participants. It just makes things harder another thing to keep track of. Sure.
No other questions in the room?
Or you can come up after, and then we'll respond to people on the webinar.
Absolutely. Well, then I will close us out today. I want to thank you for joining us and spending some time with us this afternoon. Have a good afternoon, everyone.